No, I don't think it's wrong, and I don't think you are changing the referees in the middle of the game. The EC members are supposed to be independent.
Yes.
But being independent does not mean you are not accountable. They are also supposed to be accountable. And the accountability mechanism is the petitioning process that Article 146 outlines. Article 146 empowers any citizens who sees wrongdoing at the Electoral Commission to file a petition with the president, and when they file that petition, the president has no choice but to convey the petition to the Chief Justice, who would look at the facts and determine whether there's a prima facie case, and if there is, he would form a committee, and the committee would sit as a court of 5 people, hear evidence, give all the benefit of doubt to the EC members, and then if they believe the charge of misbehavior or incompetence has been proven, then they'll make a recommendation to the president, and that recommendation is binding on the president. In other words, the president has nothing to do with the removal of the EC. He's just announcing what it is that a duly constituted constitutional commission.
But would the public understand that?
That's your role. That's my role, to educate the public on what is going on. There are politicians who will take advantage of the situation and say, well, you see, the president doesn't like the EC members and that's why he's removing them. But we know as a matter of fact that that has not happened. And I want to relate the removal of the EC members and the chairperson to the appointment of the EC members, because in both cases, the Constitution provides similar language. When it comes to the removal, it says the president, acting on the recommendation of the committee, would remove the members. When it comes to the appointment, the Constitution says the president, acting on the advice of the Council of State, would appoint the members. In both cases, I do believe that the best and proper and only way to interpret the language is that the president serves only a ministerial function. He plays only a ministerial role. The president is a head of government, but he's a head of state. And as a head of state, he does a lot of things that is just ceremonial in nature. One or two of those things is the act of appointing the EC members, even though substantively the appointment is done by the Council of State, and the act of removing the EC members, even though substantively the EC members are removed by a judicial process that occurs outside the purview of the president.
But it's interesting you say this, because Richard Sky, who works here, and the Ghana Bar Association went to court a couple of years ago, if not last year, on this same issue, arguing that the Council of State must be more active and the president's role must be passive. But the Supreme Court did not rule in their favor. So actually, what the Supreme Court is saying, if this president decides to actively choose somebody and get the Council of State to just rubber stamp it, the Supreme Court's judgment would support that.
Yeah, I'm aware of that judgment, and of course, I don't agree with that judgment, because the president in the Constitution does a lot of appointments, some in consultation with, some on their advice, and some he just does the appointment. And we have to really pay attention to the mode of appointment. When it comes to acting on the advice, the proper way to interpret the Constitution is that he is indeed bound by the advice that is being given. Otherwise, if we accept the court's decision in the Sky case and the GBA case, then similarly, we must read the removal in tandem, right? Because the language is similar. The president acting on the recommendation. Now, recommendation is even weaker than advice. So are they saying that the president can ignore the recommendation of the committee? I don't think so. And that by itself should tell us there's something structurally and fundamentally wrong with the decision as rendered.
Wow.
But it is not the first time that the court would make a decision that I disagree with. There's one decision that I disagree vehemently with, the constant swearing in of the speaker when the president and vice president travel outside the country. This is an issue that I took to court, I believe, in 2002, and the court said, no, the Constitution says that when the president and vice president are out of the country, then they are unable to perform their functions. Now, nobody who reads law, nobody who has taken a class in English comprehension would arrive at the decision that the court arrived at.
Are you serious?
I am serious.
Because I remember that case as well in fact, there was an instance where the then speaker, Do Ajaho, did not swear the oath. And again, somebody here, Samuel Atamensa, took the matter, and it was a 9-0 that he ought to have sworn in that oath when the president was absent and the vice was absent.
Yes.
So what are you saying? Are you saying that our Supreme Court sometimes gets things wrong?
Not just our Supreme Court, all courts. Courts have the final word, but they are not infallible.
Because their judgments are law.
Yes, but I repeat, they are not infallible. They have the final word. Sometimes they themselves will get up and say, well, this case in 2004, we said X, well, we are wrong. We are changing our mind. We have courts all over the world ruling that black people are not full human beings and so on. So just because the courts have spoken, that gives us finality. We can go about and do our things. We accept the decision, but we don't have to agree with the decision. And when you go to the law schools and when you go to the journals, there's a lot of criticisms of these decisions. And the way that we hold judges accountable is to scrutinize their decisions.
So let's go back to the EC issue. You're saying the president, in allowing the petition process in terms of the removal of the EC, did the right thing by being passive. He should continue his passivity in the appointment by allowing the Council of State to take the lead role in appointing a new EC chairperson?
Yes,
is that what you're saying?
Yes, I believe so. I believe that is what the Constitution anticipated. The framers of the Constitution naturally would have understood that the president is a political player. The framers took Parliament out of the equation because Parliament is a hall of politicians. They could not have taken the MPs out of the equation and just left the president alone to appoint the members of the Electoral Commission, to use your language, the referees of the game. So I just believe that the court erred rather seriously when they ruled the way they ruled in the Sky and GBA case. I've written about that advice in a constitution is a term of art. It's a way of giving binding instructions to a constitutional officer. The genesis of that language can be found in our 1957 Constitution, when it was said the Queen in England appointed the ministers acting on the advice of then Prime Minister Kwame Nkrumah. Nobody seriously believed the Queen in England was the one who was doing the appointment. The Queen appointed because under our 1957 Constitution, which was a monarchical constitution, the Queen was the head of state. So when the Queen was appointing the ministers, she was doing it in her role as head of state.
Not head of government.
Not head of government. The appointment was actually done substantively by the head of government. It is that 1957 language that has been copied and exported into our 69, 79, and now 1992 Constitution. The Council of State, the Constitution framers, envisioned them to be a body of wise men. And they felt they could be insulated from politics. And that's why they assigned them that role. I'm afraid we have read the Constitution again to give the president powers that he doesn't have. Often we complain that the president has too much powers. And then we turn around and just add more powers.
But now, as we are speaking today, Mr. Kwaku Asare, who is a well-known journalist and social commentator, he's gone to court and is essentially challenging what the committee the Chief Justice set up decided. So Kwaku Asare's argument is that, among other things, the committee that recommended the dismissal of the EC chairperson and the other two they went beyond their powers. So essentially, first point, do you think that should truncate the process of appointing a new chairperson until that matter is determined? Because as we speak, the law that the president is working with would be what is in the constitution plus the judgment that was delivered in the Sky case. So he would probably minded to go and appoint a new EC chairperson. But Mr. Baku is saying no. The committee, because that committee was triggered by the Chief Justice, right? So in this case, the president was acting as head of state. So what's going to happen?
Well, here again, I would call on the president to be transformational rather than transactional. Yes, the Supreme Court has said he has that appointment, but he must, as a lawyer, read the Constitution himself and put it in context. Did the framers of the Constitution seriously want the president alone to appoint members of the Electoral Commission to referee the political game? If he does that, and he says, well, I know the Supreme Court says I have the power, but on the face of it, that doesn't sound right, and I'm going to stay out of the process and allow the Council of State to put in place a mechanism to search for the 3 members of the Electoral Commission, I think history would favor him. He would have done a good thing.
Wow.
Second, I have not read the writ filed by Mr. Baku.
Yes.
It will be interesting to read that. But just based on what I've read in the newspapers, based on those snippets, the idea that misbehavior must be tied to the core functions of the administrative body that is being removed, I think it's a funny idea. It's not going to see the light at all. That has no merit whatsoever.
Great.
And funny enough, I put together a hypothetical on my Facebook wall today on the same issue. I changed the facts a little bit.
One Yao guy.
One Yao guy, yes.
What was the verdict from your followers?
Well, they all saw that Yao could be removed, even though what he was doing was not related to his core function.
So you're arguing that even if procurement is not a core function of the EC chairperson, procurement misconduct could result in a person as EC chair being removed. So you agree with what the committee put?
Yes, absolutely. Anything that leads the public to question your trustworthiness, and one of those things could be a violation of the procurement laws. Now, I happen to disagree with the notion that procurement is not part of the core function of the EC. The EC must do a lot of procurement in order to organize elections. And so the notion that somehow we can take procurement away from what they do is itself laughable on the face.
Great. This is to the point of view. I have a couple more points to raise. We're going to talk about one issue he's been very, very critical about, the issue of dual citizenship. And for that, I'm going to put up a post because you don't seem to... You have a lot of issues with Parliament, right? And I saw one of your posts where you said, there's nothing more contemptuous than MPs bringing contempt charges against an MP who is defended by lawyers who are MPs in proceeding presided over by an MP in Parliament where MPs resolve the issue by the usual motion to adjourn. And I'm tracing this post not just to the fact that you are not happy with the whole thing, but even who becomes an MP is an issue for you. Because I've read you talk about 94(2)(a), that for somebody to become an MP, he needs to owe allegiance to only Ghana. So let's start with that and come to this. You feel that that is discriminatory and completely archaic?
94(2) is not just about MP. If you are not qualified to be an MP, then you will not be qualified to be president, you will not be qualified to be speaker, you will not be qualified to serve on the Electoral Commission, you will not be qualified to form a political party, you will not be qualified to serve on the executive. So 94(2) states something which then has a lot of implications.
Good.
Now, the reason why I have problems with Article 94(2) is because it is misunderstood. When you read Article 94(2), it did not say anything about citizenship. It did not say anything about dual citizenship. But somehow, 94(2) has been opportunistically interpreted as applying to dual citizens. And that interpretation should be dismissed on the face of it. Why?
Okay.
Because we know, or anybody who knows the Constitution, also knows that in 1992, this constitution did not even allow dual citizenship. If you were a Ghanaian and you became a citizen of another country, your Ghanaian citizenship automatically was taken away from you. That is Article 8(2). So it cannot be the case that the Constitution did not allow dual citizenship and then had a clause which says, oh, by the way, if you are a dual citizen, you cannot be a parliamentarian. Article 94(2) is addressed to people who are registered Ghanaians. Registered Ghanaians means they were not born Ghanaians, but they migrated to Ghana and they have applied to become Ghanaian citizens. They could apply to the minister to give them time to renounce their other citizenship. Article 94(2) is saying during that window that they are applying to renounce their citizenship, they cannot serve under Article 94(2). So that is really what Article 94(2) is.
So you're
all
saying
about.
that if the Constitution says you can't be an MP and consequently whatever other position MPs can hold or people who are similar to MPs, the clause that says owing allegiance to another country does nothing to do with being a Ghanaian citizen?
No.
So, but I thought inherent in citizenship is allegiance.
No.
So because you swear, when you become a citizen of a country formally, because there are two things, right? When you are born a citizen, that's when you don't say I'm a citizen, but when you acquire Ghanaian citizenship by, say, marriage or some other means, you take some oath?
You take an oath.
Of allegiance to the country.
Yes, but what does that mean? I mean, when you read the Australian Constitution, and we are a Commonwealth country, so we all copy that language, you see that the allegiance clause we copied from, again, the Commonwealth. The Australian Constitution says a person who owes allegiance to a country other than Australia or is a dual citizen. We dropped that dual citizen from our laws. And the reason we did that was because Ghana is a nation of dual citizens. At independence, we were either British subjects or British protected persons. Those from the colony or those from Ashanti were called British subjects, and those from the Northern Territories were called British, the protectorate. And then we had Transvolta, the trustees. The trustees and the protectorates were called protected persons. The long and short of it is that we were British subjects under the British nationality law. And then when Ghanaian citizenship came into being, in May 1957, it did not take away our British citizenship or British subject.
Interesting.
And so at independence, we were all dual citizens. And so if we had adopted that language, there would be nobody in Ghana who would qualify to become an MP or even a prime minister. So Ghana has always been about dual citizenship. And I gave a talk last week where I quoted President Kufuor in 1969, where I quoted Ubeda Samoa in 1969, where I quoted Joe Appiah in 1969, strongly making the case that in our country, if you are a Ghanaian, then it doesn't matter what other citizenships you have. You are entitled to the bundle of rights that attach to citizenship.
We'll be back on the point of view to read your messages and also talk about the other issue before we close. So 6 new regions are being created, or the intention has been made. We'll find Mr. Azar's view on that, and I'll read some of your comments. This is the point of view. Don't go away.